Based on the CPS investigation and the removal of the children from the plaintiff mother, the kids have been in the care of my client for 9 months. So I have grave concern about the safety of these kids being returned back to the mother. There are pending felony charges against Miss Lee in this county. The case was concluded based on the CPS's failure to comply with the court's scheduling order. There's never been any resolution or decision made on the merits. The allegations are serious. There are allegations of neglect, and those remain unresolved.
Okay. Well, on the record now in Lee versus Lee, this is file number 2419864. If I could just have both counsel put your appearances on.
Yes, thank you, Your Honor. Attorney Cal DeBrucker with and on behalf of the plaintiff, Renora Lee, and we both appear separately via Zoom today.
Good morning, Judge Elliott Blumberg on behalf of Timothy Lee, who's also appearing via Zoom.
All right, thank you. We're on the record today for a status conference in this file. I know we did at one point have a motion scheduled, I believe, on Wednesday regarding an order, a prior order that had been entered in light of, I believe, a CPS investigation, which is now concluded. But other than that, this was set for a status conference today. So I guess, Mr. DeBrucker, on behalf of the plaintiff, I would address you first, and if you could tell me where things are at, in particular in terms of any, property division aspect of the divorce here.
Yes, Your Honor. Thank you. I think, opposing counsel and I had some discussions regarding the asset and property division just before this case went on the stay per stipulation pending the CPS investigation, which has now concluded if the court's not aware, hence the filing of our motion regarding parenting time, as well as lifting the stay. It doesn't appear that the parenting time motion hearing is necessary at this point. My client does have possession of the kids, is my understanding, but I do believe we still need to lift the stay. We did have a quick objection hearing on recommended support issues with the referee last week, and we anticipate new calculations coming from that, as well as a continued evidentiary hearing that we had started, I think, back in November of last year, Your Honor. So really, I think a lot of our focus has been on the custody and parenting time and the CPS case and things of that nature. I don't think there's a whole lot for these parties to divide. They have been separated for a couple of years now, I believe. So I don't really foresee any major issues regarding division of assets and debts. There's no real estate. I think it's probably getting some of the personal property items maybe that might be in dispute resolved.
All right, thank you, Mr. Blumberg.
Judge, I would agree only to the extent that there isn't significant assets to be divided. The real issue is the custody situation. Based on the CPS investigation and the removal of the children from the plaintiff mother, the kids have been in the care of my client for 9 months. She has been provided very limited parenting time during that time. The case was concluded based on the CPS's failure to comply with the court's scheduling order. There's never been any resolution or decision made on the merits. The allegations are serious, and those remain unresolved. There's never been any resolution or decision made on the merits because of the failure of the attorney to file a witness and exhibit list. There were some procedural issues arising from that case, but in terms of the merits of the case, it's never been decided or heard. So I have grave concern about the safety of these kids being returned back to the mother. Again, they had been in the care for 9 months. So now with the reversion back to the old parenting time schedule and custody order, my client has very limited contact with the kids. My understanding is that the plaintiff continues to reside in the parties that were alleged to have abused these kids. So I think the property issues aside, we need to get this matter heard either before the referee or Your Honor, because the current arrangement causes significant concerns.
Okay. Has there been, are there any motions pending before the referee? What is the status?
I had filed an ex parte motion that the court denied. the court generally then would refer that motion to the referee, and I don't know that Your Honor did that, so I don't think there is any pending motions as of today.
All right, Mr. DeBreiker, would you agree that this does need to be referred to friend of the court for a determination by the referee, and then potential further hearings after that?
Yes, Your Honor, I would agree that we do need hearings on the custody and parenting time.
Okay.
And support, for that matter.
Okay, so I'm going to issue a status conference order referring this to friend of the court to schedule a hearing on those issues, and then we'll proceed on that track. In terms of the property division aspect of the divorce, I'm not going to set any further hearings. It doesn't sound like that's something that's going to require a lot of court time to resolve. So that's how we'll go forward. And I will, again, refer it to the friend of the court, and the friend of the court will send out notice of hearing for those issues. Mr. DeBreiker, is there anything else we can address for your side today?
None on my end, Your Honor. Thank you.
Mr. Blumberg?
Judge, I don't mean to be difficult, but there are pending felony charges against Miss Lee in this county. And I know you perhaps are not in a position to make any findings, but the one that we are reverting back to, again, places these kids in her care and denies my client.
Mr. Blumberg's frozen on my screen, just
Very little parenting time.
Mr. Blumberg, can you just repeat, you froze up there. Can you just repeat maybe the last minute of what you just said?
Sure. I don't know if it's on our end or not, but again, the referral by the court is appropriate, but the reality is we're not going to have an evidentiary hearing until in the fall. And again, I'm not in a position to ask the court to make any findings as to those allegations, but I would ask the court to at least be mindful of those allegations, because there were at least substantial findings by CPS to place the kids away from the mother and in the care of the father. I don't know what safeguards the court can put on this situation today, but I would ask the court to at least give some consideration to that.
Well, I'm certainly going to request, and we'll put that in the order, that friend of the court, schedule this for the next possible hearing date. Of course, the court is mindful of any danger to minor children. I guess, what I would note is that there's been allegations on both sides of abuse of these children. And so as I sit here today, it's hard for me to determine which side or whether both are being abusive or whether neither are. So I appreciate your statements, Mr. Blumberg, but certainly I think the same could be said of your client in terms of allegations. So, the court's in a position where we need to have some evidentiary hearings for the referee and potentially the court later to make findings based on the evidence that's produced, rather than, allegations going back and forth between both parties.
I appreciate that.
So I think what I can do today in terms of that, absent, further ex parte or emergency motions, is to try and expedite it as quickly as I can to get the evidence in front of a fact finder.
Understood.
Okay. All right. Thank you. So I will issue that order today. The friend of the court will get those dates out as soon as possible, and all parties on this file are free to disconnect at this time. And Mr. Blumberg, I know you have a 9:15 and a 9:45, but I do have a hearing in between there, so I'm just going to put you in the waiting room for just a moment.
Okay. Thanks, Judge.